Morning, Chair.
Thank you. I am going to deliver my decision in the application brought by Mr. Moyane for leave to cross-examine Mr. Gordhan. A typed version will not be immediately available, but it will be available in the next few days. So, but otherwise it will be subject to one qualification, a full decision.
Thank you, Chair. The legal representatives of Mr. Moyane are present, and the legal representative, Mr. Gordhan, have asked to be excused.
Thank you.
May I be seated during?
Yes, you may be seated. Thank you. This is an application brought by Mr. Thomas Swabehi Moyane for leave to cross-examine Mr. P.J. Gordhan, the Minister of Public Enterprises, who submitted a statement in this commission last year and subsequently gave evidence. I shall refer to Mr. Moyane as the applicant. A copy of Mr. Gordhan's statement was sent to the applicant by the Secretary of the Commission in accordance with Rule 3.3 of the rules of this Commission. A notice contemplated in Rule 3.3 was also sent to the applicant. In support of his application, the applicant delivered a founding affidavit with extensive annexures, as well as a supplementary affidavit, also with annexures. Mr. Gordhan opposes the applicant's application. In support of his opposition, Mr. Gordhan delivered an opposing affidavit with extensive annexures as well. Thereafter, the applicant delivered a short replying affidavit with annexures. In due course, the applicant's counsel and Mr. Gordhan's counsel delivered written submissions on the applicant's application for leave to cross-examine and Mr. Gordhan's opposition thereof. I subsequently had oral argument presented by counsel for the applicant, Mr. Mpofu SC, counsel for Mr. Gordhan, Ms. Leroux, and some limited comments by the head of the Commission's legal team, Mr. Pretorius SC. I'm indebted to all counsel for their written and oral argument. After hearing argument, I reserved my decision and indicated that I would announce it in due course. Subject to one qualification that I will deal with later, this is my decision. In order to properly consider the applicant's application, it is necessary to first refer to the legal framework within which an application for leave to cross-examine a witness before this commission must be evaluated in order to decide whether leave should be granted or refused. The legal framework. This commission was appointed in terms of Section 84 of the Constitution. The Commissions Act has been made applicable to it. Certain regulations have been promulgated that apply to it. Neither the Constitution nor the Commissions Act contains any express provision relating to the cross-examination of witnesses by anybody adversely affected by any statements or evidence of a witness in a judicial commission of inquiry such as this one. However, Regulation 8.3 of the regulations applicable to this commission provides, and I quote, Any witness appearing before the Commission may be cross-examined by a person only if the chairperson permits such cross-examination should he deem it necessary and in the best interest of the function of the Commission. Close quotes. Regulation 15 reads, the Commission may determine its own procedures, in quotes. Pursuant to Regulation 15, the Commission has determined its own rules. Rule 3.1 of the rules of this Commission provides in effect that, as a general rule, the Commission's legal team bears the overall responsibility to present the evidence of witnesses to the Commission. This is subject to anything to the contrary contained in the rules or subject to the chairperson's directions in regard to any specific witness. Rule 3.3 sets out what the Commission's legal team is required to do if the Commission is in possession of a statement by a witness who is to give evidence before the Commission when his or her evidence implicates or may implicate another person. Rule 3.3 reads, and I quote, if the Commission's legal team intends to present to the Commission a witness whose evidence implicates or may implicate another person, it must, through the Secretary of the Commission, notify that person, in brackets, implicated person, in writing within a reasonable time before the witness gives evidence. 3.3.1, that he or she is or may be implicated by the witness's evidence. 3.3.2, in what way he or she is or may be implicated, and furnish him or her with the witness's statement or relevant portions of the statement. 3.3.3, of the date when and the venue where the witness will give the evidence. 3.3.4, that he or she may attend the hearing at which the witness gives evidence. 3.3.5, that he or she may be assisted by a legal representative when the witness gives evidence. 3.3.6, that if he or she wishes, 3.3.6.1, to give evidence himself or herself, 3.3.6.2, to call any witness to give evidence on his or her behalf, or 3.3.6.3, to cross-examine the witness, he or she must, within 2 weeks from the date of notice, apply in writing to the Commission for leave to do so. And 3.3.7, that the chairperson will decide the application, close quotes. I shall refer to the procedure set out in the provisions of this rule as the Rule 3.3 procedure. It will be seen from the introductory part of Rule 3.3 that the Rule 3.3 procedure only applies, and I quote, if the Commission's legal team intends to present to the Commission a witness whose evidence implicates or may implicate another person, close quotes. This means that the Rule 3.3 procedure does not apply if the evidence of the witness proposed to be presented to the Commission does not or will not implicate the person who seeks leave to cross-examine the witness. The purpose of the phrase, and I quote, evidence that may implicate another person, close quotes, in the introductory part of Rule 3.3 is to ensure that where the Commission's legal team is not certain whether the evidence of a witness implicates a particular person, but but think that it is arguable that it does, they send a Rule 3.3 notice to that person and leave it to him or her to take a view whether or not he or she is implicated or will be implicated by the witness's evidence. In both cases, the Commission's legal team will be obliged to send the affected person a Rule 3.3 notice. Once a person has received a Rule 3.3 notice, he or she must take his or her own view whether he or she is implicated, and if so, what steps he or she wants to take. Rule 3.3.6 makes provision for a person who, for example, seeks to cross-examine such a witness to apply to the Commission for leave to do so. If the person concerned does not wish to cross-examine the witness, he or she is not obliged to do anything. However, even where a person has taken the view that he or she is not implicated or has not done anything pursuant to the receipt of a Rule 3.3 notice, the chairperson of the Commission still has power under both Regulation 10.6 as well as under Rule 3.10, should he choose to do so, to direct such a person to respond to allegations made against him or her. In terms of Regulation 10.6, the chairperson may issue a directive directing or requiring any person to depose to an affidavit and deal with certain issues, or directing the person to appear before the Commission and be questioned on matters falling within the terms of reference of the Commission. Excuse me. Rule 3.3.6 provides that the Rule 3.3 notice must notify the implicated person that if he or she wishes to cross-examine the witness, he or she must, within 2 weeks from the date of the notice, apply in writing to the Commission for leave to do so. Once the Secretary of the Commission has received an application for leave to cross-examine, he or she must place the application before the chairperson and give a copy thereof to the Commission's legal team. The chairperson may then issue directions as to the future conduct of the application, including giving the witness the opportunity to oppose the application by delivering an answering affidavit. The first important point to make in regard to an application for leave to cross-examine a witness is that it must be made by a person who is or may be implicated in the witness statement or evidence. In other words, he or she must be able to state that he or she is implicated by the witness concerned in his or her statement. If a person is not implicated or cannot be said to be implicated in a witness statement or in the witness evidence, he or she is disqualified from making an application for leave to cross-examine. Furthermore, an applicant for leave to cross-examine must identify those parts of a witness statement which he or she says implicate him or her. He or she may disagree with the contents of a Rule 3.3 notice in the sense that while such a notice may state or suggest that he or she is or may be implicated in the witness statement or evidence, or is or may be implicated by a certain part or parts of a witness statement, he may take the view that he is not implicated as suggested or at all. Rule 3.4 is the rule that governs the submission of an application for leave to cross-examine and its content. The rule reads, and I quote, "An application in terms of Rule 3.3.6 above must be submitted in writing to the Secretary of the Commission within 14 calendar days from the date of the notice referred to in Rule 3.3. The application must be accompanied by a statement from the implicated person responding to the witness's statement insofar as it implicates him or her. The statement must make it clear what parts of the witness statement are disputed or denied, and the grounds upon which those parts are disputed or denied. Close quotes. Excuse me. The second sentence of Rule 3.4 obliges an applicant for leave to cross-examine to make sure that his or her application is, and I quote, accompanied by a statement from the implicated person responding to the witness statement insofar as it implicates him or her, close quotes. The word from in the second sentence of Rule 3.4 must be read as meaning by, in quotes, with the result that the statement that is said to be a statement from an implicated person is a statement by the implicated person. The part of Rule 3.4 which reads, and I quote, responding to the witness statement insofar as it implicates him or her, close quotes, qualifies the implicated person's statement that must accompany the application for leave to cross-examine. That part of the first sentence of Rule 3.4 referred to in the preceding paragraph must be read with the last sentence of Rule 3.4. The third and last sentence of Rule 3.4 reads, and I quote, the statement must make it clear, that is the statement by the implicated person, must make it clear what parts of the witness statement are disputed or denied and the grounds upon which those parts are disputed or denied, close quotes. This sentence requires the implicated person's statement to make it clear what parts of the witness's statement are denied or disputed and the grounds upon which those parts are disputed or denied. The purpose of the second and third sentences of Rule 3.4 is to ensure that an implicated person does not simply provide a bare denial to a witness's statement that implicates him or her, or to a part of a witness's statement that implicates him or her. Read together, these two sentences require or oblige an implicated person to do three things, namely, A, identify the parts of the witness's statement that he or she accepts implicate him or her. B, respond to the parts of the witness's statement that implicate him or her by stating whether he or she admits or denies them and setting out his or her version in regard to the incident or event or allegation. And C, ensure that his or her response or statement or affidavit provides the basis or grounds upon which he or she disputes or denies the version or allegation or evidence implicating him or her as reflected in the witness's statement or evidence. It should be clear from the above that part of the idea behind Rule 3.4 is that the chairperson, who must decide the application for leave to cross-examine, is fully apprised of what is common cause between the respective versions of the witness and the implicated person or persons, and where the areas of divergence between them are. This enables the chairperson to have a full picture of the position when he considers the application for leave to cross-examine, so that he can take into account the extent of the divergence in the two persons' versions in determining how much time will be appropriate to allocate for the cross-examination should he grant leave to cross-examine. If cross-examination is granted, it takes place within the context of the witness's version as well as the version of the implicated person and the grounds or basis upon which the witness statement is or certain parts of the statement are denied or disputed insofar as the statement implicates the applicant for leave to cross-examine. As already stated earlier, Regulation 8.3 provides, and I quote, "Any witness appearing before the Commission may be cross-examined by a person only if the chairperson permits such cross-examination, should he deem it necessary and in the best interests of the function of the Commission," close quotes. Rule 3.7 then reads, and I quote, "In accordance with Regulation 8.3, there is no right to cross-examine a witness before the Commission, but the chairperson may permit cross-examination should he deem it necessary and in the best interests of the work of the Commission to do so," close quotes. And Rule 3.6 reads, "In deciding an application contemplated in Rule 3.3.6, the chairperson may, in his discretion and on such terms and conditions as he may deem appropriate, grant leave to an implicated person to," and then C, "cross-examine the witness implicating him or her," close quotes. Rule 3.7 basically says the same thing as Regulation 8.3. What Regulation 8.3 and Rule 3.7 mean is that in determining whether an application for leave to cross-examine should be granted, the chairperson must ask the question whether, and I quote, "it is necessary and in the best interests of the function or work of the Commission to," close quotes, "grant the applicant leave to cross-examine the particular witness whom he or she wishes to cross-examine. If the chairperson takes the view that it is, he grants leave. If he takes the view that it is not, he does not grant leave. Therefore, the test for determining the merits of an application for leave to cross-examine is whether it is necessary and in the best interest of the function of the Commission for the chairperson to grant leave." It can be seen from the above discussion of the rules of the Commission that the first requirement that an applicant for leave to cross-examine must satisfy is that the statement or evidence of the witness whom he or she wishes to cross-examine implicates him or her. If he or she fails to show this, his or her application is defective and may be dismissed or will be dismissed. If an applicant for leave to cross-examine succeeds in showing that he or she is implicated in the statement or evidence of the witness, then he or she must state, in accordance with the second and third sentences of Rule 3.4, what he or she admits in the witness statement or evidence and what he or she denies or disputes, set out his or her full version of the incident or to the allegation and state what the grounds are for denying or disputing the witness statement or parts thereof. He or she must then show that it would be necessary and in the best interest of the function of the Commission for the chairperson to grant him or her leave to cross-examine the particular witness. If he or she succeeds in showing all this, the chairperson grants him leave or may grant him leave to cross-examine the witness. If he or she fails, the chairperson will or may dismiss the application. Rule 3.6 makes it clear that in deciding an application for leave to cross-examine, the chairperson exercises a discretion. That discretion must be exercised judiciously with due regard to all relevant circumstances. From the above analysis of the provisions of Regulation 8.3 and various rules of the Commission, what emerges is that some of the important requirements that a person who applies for leave to cross-examine a witness before this commission must satisfy are that A, must deal with is that there is no right to cross-examination, but the chairperson may grant leave to cross-examine in certain circumstances. The witness implicates the applicant for leave to cross-examine. The applicant must clearly identify the parts of the witness statement or evidence which implicate or implicates him or her. The applicant for leave to cross-examine must state whether he admits or denies or disputes the witness' allegations or evidence that implicate or implicates him or her, and he or she must set out his or her version in relation to any allegation or evidence by the witness or in relation to each incident and the grounds upon which he or she denies or disputes or qualifies the allegation made or evidence given by the witness. The chairperson exercises the discretion in granting or refusing an application for leave to cross-examine. In determining whether to grant or refuse an application for leave to cross-examine, the chairperson considers the test to which reference has been made above. In principle, a principle that is not expressly articulated or covered by the rules, but is of obvious application, is that an applicant for leave to cross-examine must take the commission into his or her confidence and disclose his or her true and full version in regard to any allegation made or evidence given by the witness that implicates him or her. Obviously, an applicant for leave to cross-examine who fails to take the commission into his or her confidence and disclose his true version of the matters risks having that factor taken into account against him or her in the chairperson considering the application for leave to cross-examine. Despite the fact that the applicant's affidavits were deposed to in support of an application for leave to cross-examine, they reflect the applicant's attitude as being that he has a right to cross-examine Mr. Gordhan. This position is also reflected in the applicant's counsel's written submissions. However, to his credit, when Mr. Mpofu SC, who appeared for the applicant as I have indicated, presented his oral argument on behalf of the applicant, he quite correctly made it clear that he accepted that in this commission, the applicant has no right to cross-examine, but has to apply for leave to cross-examine, and will only have that right if the chairperson grants him leave to cross-examine. Mr. Mpofu also accepted that the applicant is required to also give his version in regard to matters in which he is implicated in Mr. Gordhan's statement or evidence. It is now necessary to consider or to apply the requirements that I've discussed above to the application before me. In applying the rules as discussed above to the applicant's application and Mr. Gordhan's opposition of that application, the first issue for the applicant is whether, as required by Rule 3.3, the applicant has shown that he is implicated in Mr. Gordhan's statement or evidence. In respect of many issues in his founding affidavit, where the applicant articulates issues in respect of which he seeks leave to cross-examine Mr. Gordhan, the applicant has not shown that he is implicated in Mr. Gordhan's statement or evidence. However, there are a few areas in his founding affidavit in which it is shown that he is implicated in Mr. Gordhan's statement or evidence. I shall deal with these in due course. I have also made the point that Rule 3.3 requires from an applicant for leave to cross-examine a statement responding to the witness statement insofar as it implicates him or her. This means that an applicant for leave to cross-examine must respond to those parts of the witness's statement which implicate him or her. The applicant's statement in this case does not at all respond to certain important parts of Mr. Gordhan's statement which implicate him, or does not respond adequately to some parts of Mr. Gordhan's statement or evidence. One example of this relates to paragraph 127 to 127.4 of Mr. Gordhan's statement, where Mr. Gordhan implicates the applicant of blatant refusal, quote, to account to him as Minister of Finance on material issues, in brackets, such as the operating model of SARS, close brackets and close quotes. Mr. Gordhan accuses the applicant of even refusing to acknowledge his authority, and Mr. Gordhan suggests that this conduct on the applicant's part appeared to have been part of a campaign aimed at forcing him to resign as Minister of Finance. He says the applicant made serious allegations against him and continued to refuse to accept that he was accountable and answerable to him as Minister of Finance. The applicant, as I've indicated, does not respond to these allegations in Mr. Gordhan's statement and put his version. Furthermore, I have also stated that Rule 3.4 requires the statement of an applicant for leave to cross-examine to make it clear which parts of the witness's statement are disputed or denied and the grounds upon which those parts are disputed or denied. Because the applicant's affidavits in this case do not identify or do not clearly identify the parts of Mr. Gordhan's statement that are denied or disputed, it cannot be said that it complies with that part of Rule 3.4 that requires that an applicant's statement make it clear what parts of a witness statement are disputed or denied. One struggles to see which parts of Mr. Gordhan's statement the applicant admits or disputes. The applicant's statement should have made this quite clear. Rule 3.4 obliges an applicant for leave to cross-examine to also give his version in regard to allegations made by a witness or in regard to evidence given by a witness. It will also have been clear from the discussion of Regulation 8.3 and Rule 3.7 that an applicant for leave to cross-examine is required to show that it is necessary and in the best interest of the function or work of the Commission that he or she be granted leave to cross-examine. Neither in his founding affidavit nor in his supplementary affidavit did the applicant deal with the issue of why it can be said that granting him leave to cross-examine Mr. Gordhan is necessary and in the best interests of the function of the Commission. I've read his affidavits carefully and I'm satisfied that he does not address this important issue. As an applicant for leave to cross-examine, he should have addressed the question of why I should conclude that it is necessary and in the best interest of the function of the Commission that he be granted leave to cross-examine Mr. Gordhan. By contrast, in his opposing affidavit, Mr. Gordhan specifically contended that the first reason why he opposes the applicant's application is that it, and I quote, fails to comply with the requirements of Rules 3.4 and 3.7, close quotes, of the Commission's rules. Both Rule 3.4 and Rule 3.7 have been quoted above. Rule 3.4 is the rule that, among other things, requires an applicant for cross-examination, or rather, an application for cross-examination to be accompanied by the applicant's or implicated person's, and I quote, statement responding to the witness statement insofar as it implicates him or her, close quotes, and that such statement by the applicant or implicated person, open quotes, must make it clear what parts of the witness statement are disputed or denied, and the grounds upon which those parts are disputed or denied, close quotes. Rule 3.7 is the rule that effectively mirrors Regulation 8.3, and is to the effect that in this commission there is no right to cross-examine, but the chairperson, open quotes, may permit cross-examination should he deem it necessary and in the best interest of the work of the commission to do so, close quotes. Rules 3.4 and 3.7 are therefore, together with Regulation 8.3, at the heart of the consideration of an application for leave to cross-examine a witness before this commission. In support of his contention that the applicant's application fails to comply with Rule 0.3 and 3.7, Mr. Gordhan said in his affidavit, and I quote, 6.1, contrary to those requirements, the application fails to make it clear what parts of the witness statement are disputed or denied, and the grounds upon which those parts are disputed or denied, close quotes. 6.2, nor does it establish that cross-examination is necessary and in the best interest of the work of the Commission to do so. 6.3, this defect is a basis to dismiss the application in its entirety, close quotes. Mr. Gordhan also pointed out that he was advised that the purpose of cross-examination would be to test his evidence against an alternative set of facts provided by the applicant. But, said Mr. Gordhan, the applicant did not put up any alternative set of facts or any evidence contradicting his evidence. Mr. Gordhan stated in his opposing affidavit that in his evidence before this commission, he had testified about the applicant in three respects. He said that A, he expressed his concerns about the applicant's appointment and the applicant's resistance to his executive oversight when he was the Minister of Finance to whom the applicant was accountable. B, he provided evidence to the Commission regarding the apparent irregularity of a contract approved by the applicant in terms of which New Integrated Credit Solutions, in brackets NICS, was appointed as a debt collector at SARS, and in square brackets, the applicant's misleading statements to Parliament regarding his involvement, close quotes. C, he testified about the campaign against him when he was reappointed as Minister of Finance. That included the launching and subsequent withdrawal of criminal charges against him arising from a docket opened by the applicant. He said, I testified regarding its impact on me personally. After setting out the above three issues as the only issues that related to the applicant that he testified about in this commission, Mr. Gordhan made the point in the next paragraph that the applicant has not placed a competing factual version before the commission with which to test any of this factual evidence through cross-examination. He said that the applicant's disagreement with his personal impressions and experience does not assist the Commission. Mr. Gordhan thereafter pointed out in his opposing affidavit that, and I quote, "All three of the issues identified above regarding which I testified have been confirmed by Justice Nugent in the work of the Commission of Inquiry into Tax Administration and Governance by the SARS, in brackets, Nugent Commission, close brackets." Mr. Gordhan went on to say, and I quote, "As set out below, that Judicial Commission has investigated, considered, and made several findings that render this application by the applicant redundant," close quotes. In his replying affidavit, the applicant does not deny or dispute Mr. Gordhan's assertions that the three respects in which he says he testified about him in this commission are the only respects in which he testified about him, nor does he deny or dispute Mr. Gordhan's evidence that, and I quote, "All three of the issues identified have been confirmed by Justice Nugent in the work," close quotes, "of the commission he chaired." The applicant also does not deny Mr. Gordhan's assertion that the Nugent Commission, open quotes, investigated, considered, and made several findings, close quotes, about those three issues. Before I deal with what the applicant says in his replying affidavit, let me make one point. That is that after Mr. Gordhan had delivered and served his opposing affidavit, the applicant had an opportunity to meaningfully and directly respond to Mr. Gordhan's opposing affidavit. However, in his replying affidavit, the applicant said in part, and I quote, "I do not propose to deal with the allegations contained in the opposing affidavit ad seriatim due to the nature of my responses, which are thematic and cut across the gist of such opposition. Any allegations which are not specifically addressed but which are inconsistent with the version contained in this, the founding and supplementary affidavits, including annexures thereto, must be regarded as having been specifically denied and disputed." There are 3 points to be made in connection with this passage from the applicant's replying affidavit. The first is that the applicant says that he will not respond to all the allegations made in Mr. Gordhan's affidavit ad seriatim because his responses are thematic and cut across the gist of Mr. Gordhan's opposition. The danger with this approach adopted by the applicant is that there may be material parts in Mr. Gordhan's affidavit and evidence to which he may end up not responding, which may therefore stand as undisputed or uncontroverted. The second point is that where Mr. Gordhan's affidavit contains a version on a certain issue, and that version is inconsistent with the applicant's affidavits, and the applicant relies simply on the second sentence in the passage quoted above to say that he denies or disputes Mr. Gordhan's allegation or evidence, his denial will be nothing more than a bare denial of what Mr. Gordhan may have said in his opposing affidavit. That will not assist the applicant's application for leave to cross-examine. The third point is that there may be parts of Mr. Gordhan's affidavit and evidence which might not be said to be inconsistent with any of the contents of the applicant's affidavits. In such a case, the effect of the last sentence in the passage quoted above would be that such evidence is not denied or disputed, because the sentence says only says that what is inconsistent with what is denied or disputed, what will be denied or disputed, or must be regarded as denied or disputed, is what is inconsistent with the applicant's affidavits and annexures. The applicant does not dispute or deny any explanations that Mr. Gordhan may have given in his opposing affidavit in respect of what he may have said in his statement or evidence. In his replying affidavit, the applicant attacked Mr. Gordhan's reliance on the findings of the SARS Commission on the basis that they are irrelevant opinions. However, he failed to substantiate this contention. All he said was that they are hit by at least 3 exclusionary rules relating to opinion evidence, but he did not say what those 3 rules are. He then set out some of his complaints about the SARS Commission, which included that A, the SARS Commission had its own terms of reference. B, he was allegedly denied the right to participate in the SARS Commission. C, he will shortly be setting down Part B of his challenge to the SARS Commission's report, seeking relief to review and set it aside, and mentioned some of his intended grounds of review. I'm unable to agree with the applicant's contention that findings made by the SARS Commission in respect of issues on which he requests leave to cross-examine Mr. Gordhan are irrelevant. He himself fails to say why such findings are irrelevant, other than to say that the SARS Commission had its own terms of reference. Although the SARS Commission had different terms of reference, it may have made findings of fact that relate to some of the allegations of facts on which the applicant seeks leave to cross-examine Mr. Gordhan. Obviously, its findings are not and cannot be binding on me. However, I must have due regard to them when, among others, I consider whether it is necessary and in the best interest of the function of the Commission to grant the applicant leave to cross-examine on an issue that has been considered by the SARS Commission and in respect of which that Commission has made a finding. The applicant points out that his application was prompted by a Rule 33 notice that he received from the Secretary of the Commission. He says that that notice stated that Mr. Gordhan had submitted to the Commission a statement that implicated him in wrongdoing and pointed out 2 respects in which it said Mr. Gordhan implicated him. In his founding affidavit, the applicant states that the one respect in which the Rule 33 notice said Mr. Gordhan implicated him was in his statement. It quoted that part as well as the other respect in which the Rule 33 notice suggested that Mr. Gordhan had implicated him. The applicant put it in these terms, and I quote 5.1, my alleged participation in the awarding of the contract or tender to New Integrated Credit Solutions, a company owned by my alleged friend, Mr. Patrick Monyane, and 5.2, my alleged refusal to account to Minister Gordhan as Minister of Finance on material issues, the deteriorating relationship between the 2 of us, alleged ongoing personal and institutional attacks by me and Minister Gordhan and related relationship issues, close quotes. The applicant set out in paragraph 5 of his founding affidavit. The applicant set this out in paragraph 5 of his founding affidavit. I deal later with these 2 respects in which the Rule 33 notice said Mr. Gordhan had implicated the applicant. A proper reading of the applicant's paragraph 6 of his founding affidavit reflects that the applicant makes the point that a cursory reading of Minister Gordhan's statement submitted to this commission reveals that the issues that Mr. Gordhan raised in his statement, which directly or indirectly affected him, that is the applicant, included the following, and I quote, 6.1, the role played by Minister Gordhan as Minister of Finance to assist or oppose perceived state capture. 6.2, Minister Gordhan's requests for my removal. 6.3, his complaints about the manner in which I was employed. 6.4, his belief that I was responsible for the charges against him and others of the alleged ROC unit. 6.5, the lawfulness or otherwise of the ROC unit, and if it existed, Minister Gordhan's role in it. 6.6, my allegation of racism and disrespect towards me by Minister Gordhan. 6.7, his conduct and abuse of power related to his return to the Ministry of Finance in 2015, and more recently, the victory of President Cyril Ramaphosa at the ANC conference. This is coupled with a personal vendetta and campaign driven by Minister Gordhan to influence President Ramaphosa to complete Minister Gordhan's dream of my removal as Commissioner of the South African Revenue Service, in brackets SARS, for the sake of revenge and misplaced hatred towards me, close quotes. For convenience, I shall refer to the issues listed under paragraph 6 of the applicant's founding affidavit as the paragraph 6 issues. In paragraph 7, the applicant lists 7, in quotes, additional issues, close quotes, which he says, and I quote, are related to, in square brackets, the paragraph 6 issues, but are not directly raised in the papers, close quotes. I shall refer to the issues he lists in paragraph 7 as the paragraph 7 issues. Paragraph 7 reads, and I quote, 7, additional issues which are related to the above but are not directly raised in the papers include 7.1, Mr. Gordhan's narrative that when it comes to state capture, there is a line between the devils, open brackets, led by former President Zuma, close brackets, and the angels, of which he counts himself as one. 7.2, related to the above, Minister Gordhan's misleading of Parliament about his relationship with the Guptas, which is similar to that of other self-styled angels, such as former Minister Nene. 7.3, Minister Gordhan's role in ROC unit saga. 7.4, Minister Gordhan's improper leading role in my disciplinary inquiry. 7.5, Minister Gordhan's improper role in the Nugent inquiry, including his holding of an improper and undisclosed meeting with the Commissioner, Judge Robert Nugent, and the legal implications thereof. 7.6, Minister, in brackets, or Commissioner Gordhan's track record of mismanagement, lawlessness, and flagrant breach of procurement rules, which I was confronted with at SARS. 7.7, reports of the above of one of my predecessors, Mr. Opa Mahashula, by Minister Gordhan and his ROC unit, and the views of the current acting commissioner thereon, full stop, close quotes. In the first sentence of paragraph 8 of his founding affidavit, the applicant states, and I quote, the above make 7 topics for intended cross-examination, close quotes. It is not immediately clear whether the reference to, and I quote, above, close quotes, in the first sentence of paragraph 8 of the applicant's founding affidavit is a reference to the paragraph 6 issues or a reference to the paragraph 7 issues, because under both, 7 issues are listed. However, it would seem that the applicant must have intended to refer to the paragraph 6 issues, because he said that those were raised by Mr. Gordhan in his statement, whereas he said the paragraph 7 issues were not I quote, directly raised in the papers, close quotes. Accordingly, this matter must be approached on the footing that the issues or matters in respect of which the applicant seeks leave to cross-examine Mr. Gordhan are the paragraph 6 issues. If I'm correct that the reference to the 7 topics in the first sentence of paragraph 8 is a reference to the paragraph 6 issues, then the first sentence of paragraph 8 of the applicant's founding affidavit must be understood to mean that those are the 7 topics for the applicant's, in quotes, intended cross-examination. However, the applicant goes on to say in paragraph 8 that these 7 topics, open quotes, can be reduced to 5 broad cross-examination themes, close quotes, full stop. He lists those themes as follows, and I quote, 8.1, the general credibility and general attitude of Minister Gordhan characterized by a propensity to distort and spin the facts. 8.2, bias, hostility, and vindictiveness as guiding attitude of the relation between the two of us, leaving no room for professionalism, objectivity, and impartiality in our mutual dealings. This calls for any evidence given by Gordhan about me in any ongoing forum, including this one, to need to be taken with more than the proverbial pinch of salt. 8.3, the distortion of the evidence in order to support the false narrative of devils and angels, and specifically my alleged breach of procurement procedures. 8.4, racism and other unbecoming behavior by Minister Gordhan towards me symbolizes regrettable behavior which has no place in the nation we are all trying to build, in which there is no place for looking down upon African people. The deep role of Minister Gordhan in the Rock Unit saga, also referred to as Sunday Evening Project, which was a form of state capture, full stop and close quotes. It seems to me that the applicant's case is that he seeks leave to cross-examine Mr. Gordhan on the paragraph 6 issues using the cross-examination themes which he sets out in paragraph 8 of his founding affidavit. After outlining in paragraph 8 what he calls his cross-examination themes, the applicant says in paragraph 9, and I quote, "The rest of this affidavit will briefly outline my submissions herein, organized along the lines of the above-mentioned 5 cross-examination themes or headings, and in respect of which my version will be outlined, and the relevant supporting documents, where applicable, will be identified and annexed," full stop and close quotes. Paragraph 9 seems to emphasize that if one wants to consider the basis of the applicant's application, the proper place to look at is not after paragraph 8, except for what the applicant indicates are his versions. Paragraph 10 of the applicant's founding affidavit simply contains a request about the amount of time that the commission or the chairperson should allow for cross-examination should he grant cross-examination or leave to cross-examine. It is important to point out that from paragraph 1 to paragraph 9 of the applicant's founding affidavit, the applicant does not anywhere draw attention to any allegation made by Mr. Gordhan that implicates him in any wrongdoing. The closest to which he comes is in paragraph 6 and 6.4. In paragraph 6.3 and 6.4, In paragraph 6.3, the applicant suggests that Mr. Gordhan had, open quotes, complaints about the manner in which he was employed, close quotes. That does not say that Mr. Gordhan implicated him in any wrongdoing in regard to his appointment. In paragraph 6.4, the applicant refers to, and I quote, Mr. Gordhan's belief that he was responsible for the charges against Mr. Gordhan and others of the alleged rock unit, close quotes. On its own, this does not amount to Mr. Gordhan implicating the applicant in any wrongdoing. In any event, the applicant has admitted in his affidavit that he laid a complaint with the police which led to Mr. Gordhan and others being criminally charged. Other than this, none of the paragraph 6 issues refers to any statement or refers to any statement by Mr. Gordhan that can be said to have implicated the applicant in any wrongdoing. When one goes to paragraph 7, to the paragraph 7 issues, there too, what the applicant does is to list his own allegations or complaints or accusations of alleged improper conduct by Mr. Gordhan. They are not instances or areas in Mr. Gordhan's affidavit where he implicates the applicant. By the applicant's own admission, the paragraph 6 issues are not directly raised in Mr. Gordhan's statement. Therefore, he cannot apply for leave to cross-examine Mr. Gordhan on issues that are not raised in Mr. Gordhan's statement or in Mr. Gordhan's evidence. I have already referred to paragraph 8 of the applicant's founding affidavit, which contains what the applicant calls 5 broad cross-examination themes. In paragraph 11 of his founding affidavit, the applicant states that he is proceeding, and I quote, to outline issues to be raised by him as his version in respect of each of the broad themes identified above, close quotes. The so-called cross-examination themes start from paragraph 11 and go up to paragraph 30.7 of the founding affidavit. The balance of the founding affidavit is then taken up by a condonation application, subject to what is contained in the applicant's supplementary affidavit, with which I shall deal shortly. The applicant's case on whether or not he should be granted leave to cross-examine Mr. Gordhan is based on paragraphs 5 to 30.6 of his founding affidavit. I've dealt with all the above paragraphs except that I have not dealt with the contents of paragraphs 11 to 30.6. These paragraphs relate to the so-called cross-examination themes. I deal with them one by one. Cross-examination theme 1, that is general credibility. Under this theme, the applicant does not state what Mr. Gordhan said about him in his statement or evidence which implicates him. He simply sets out his version on certain issues. In the first sentence under this theme, the applicant states that his, and I quote, version is that Minister Gordhan's affidavit is more significant for what it omits than what it says, close quotes. I have examined everything that the applicant says under this theme. He does not anywhere state that Mr. Gordhan implicated him. Accordingly, there is no basis for him to apply for leave to cross-examine Mr. Gordhan on an issue in regard to which Mr. Gordhan does not implicate him. Cross-examination theme 2, that is anti-Moyane bias and hostility. Under this cross-examination theme, the applicant states that he, open quotes, will seek to demonstrate that the levels of acrimony, hostility, enmity, and anger harbored by Minister Gordhan towards him as a person are sufficient to disqualify him as an impartial and dispassionate commentator on any issue in which he is allegedly involved, close quotes. Elsewhere under this cross-examination theme, the applicant states, and I quote, "It will be demonstrated that Gordhan has made it his lifelong mission to have me removed from office by hook or by crook," close quotes. He also alleges that, and I quote, "Minister Gordhan's meddling in that is his disciplinary inquiry and the Nugent inquiry in square brackets, is in the circumstances improper, unlawful, unfair, and in breach of the Constitution and the rule of law in various ways, close quotes. I have also examined everything said by the applicant under this theme in the founding affidavit. He does not anywhere articulate anything that was said by Mr. Gordhan that he says implicates him in any wrongdoing. Cross-examination theme 3, that is alleged breach of procurement procedures by the applicant, in brackets, the Monyane case. It is only under this heading, or this is one of the headings that where the applicant points out that Mr. Gordhan made a direct accusation against him. The applicant states that Mr. Gordhan made a direct accusation that he, open quotes 2.1, improperly participated in the award of a tender to my friend, Mr. Patrick Monyane, and 2.2, lied to Parliament about such involvement by denying it, full stop, close quotes. In response to this, the applicant provides a bad denial. And after pointing out that it is not clear where Mr. Gordhan made the above accusations because they are not included in his affidavit nor in his evidence before the Commission, the applicant says, and I quote, "In any event, I deny these accusations and will put questions to Gordhan to demonstrate their falsity." He does not say whether he admits that he participated in the awarding of the contract, but denies that his participation was improper. He denies the entire allegation. In his opposing affidavit, Mr. Gordhan points out that he mentioned the Monyane case in his evidence. He says that he has no personal knowledge of the matter, but mentioned it in his evidence before the Commission as a suggestion that the Commission should consider investigating the case because there appeared to have been no compliance with procurement procedures. He points out that the Monyane case has already been dealt with by the SARS Commission of Inquiry. He refers to passages in the final report of the SARS Commission in which that commission made a clear finding that the applicant participated in the award of a tender to a company called New Integrated Credit Solutions. It is also stated in the SARS Commission report that the applicant approved the appointment of New Integrated Credit Solutions to the panel of service providers on 17 December 2015. It is also stated in that report that the applicant approved the appointment of that company to phase 2 of the project on 15 February 2018. It is said that in each case, the applicant did so by signing the report of the National Bid Adjudication Committee. That commission's report says, and I quote, later on, the affidavit by Mr. Gordhan continues and says, later on, and I quote, later on, the SARS Commission made this finding in its report, quote, "It is also not true that Mr. Moyane does not get involved in such appointments. His was the final approval for the award of the contract. Indeed, that assertion contradicts the assertion he made in the application to set aside the contract with LTC, the very foundation of which was that he was involved in the award of the contract. In his replying affidavit, he acknowledged expressly that he had been involved in the award of the contract. Quote, as a matter of fact, I was involved with the evaluation and adjudication of the bids. The National Bid Adjudication Committee's process resulted in a recommendation made to me in my capacity as SARS accounting officer, which recommendation I personally signed. I was also involved with the evaluation and adjudication in the sense that I'm responsible for ensuring that all procurement occurs in accordance with a lawful system, and in that the ultimate recommendations emanating from that system needed my approval, close quotes. The SARS Commission also made this finding, and I quote, "So far as Mr. Moyane conveyed that he had no hand in the appointment of new integrated credit solutions, that is not true. It is apparent from the documents that on each of the occasions that new integrated credit solutions was appointed to the panel and again appointed to phase 2, the National Bid Adjudication Committee made a recommendation to Mr. Moyane, who then approved it by appending his signature to the report. He cannot but have known that the NPAC's decision was not the end of the process, and cannot but have known that new integrated credit solutions was appointed, bearing in mind that he approved it." In regard to this transaction, the award of this contract, it is important to also point out that in his opposing affidavit, Mr. Gordhan referred to an affidavit that he said he sent to the disciplinary inquiry before which Mr. Moyane was supposed to appear. And he pointed out that in that affidavit, and that affidavit was attached to his affidavit as one of the annexures, that in that affidavit, he pointed out that indeed there was even a transcript of what was said by Mr. Moyane in Parliament in regard to the award of this contract. Mr. Gordhan made it clear that the transcript indicated that Mr. Moyane had denied that he had been involved in the award of the contract to that company. And according to that transcript and according to Mr. Gordhan, Mr. Moyane, the applicant, had admitted when he appeared before the relevant committee in Parliament that Mr. Monyane of that company was a friend of his. So the question that arises, therefore, is what it is that the applicant said to Parliament about whether he was involved in the award of the contract. If he said, as the transcript or the affidavit by Mr. Gordhan suggests, that he had not been involved, the position is that the SARS Commission found that, in fact, he had been involved in the awarding of that contract. What then becomes important is the fact that in this commission, in his application for leave to cross-examine Mr. Gordhan in regard to this issue, the applicant took the position that the allegation that made as quoted by him in the paragraph that I indicated earlier on, which is in paragraph 49 of this decision, he indicated that all those allegations were false, or that allegation of his involvement was false, and the allegation that he lied in Parliament was false. However, he did not proceed to give his full version as to what exactly he said in Parliament, and to also state whether his version is that he did not take part in the award of the contract, or whether he admits that he took part but denies that such participation was improper. It seems to me that in this regard, to say the least, the applicant failed to give his version of what happened in regard to an issue on which he seeks leave to cross-examine Mr. Gordhan. in terms of the rules as discussed earlier, he was obliged to give his full version in regard to that issue, but he has failed to do so. For that reason, in regard to his request for leave to cross-examine Mr. Gordhan in regard to that issue, therefore his application cannot be accepted in regard to that issue. The next is cross-examination theme 4, that is alleged racist and hateful utterances, impairment of dignity and vendetta. This is the fourth cross-examination theme on which the applicant seeks leave to cross-examine Mr. Gordhan. Under it, the applicant simply says, and I quote 26, these issues which will be treated as a discrete theme will have already been alluded to in different contexts above. 27, under this theme, the issue will be invoked in the separate context of the constitutional obligation contained in inter alia section 96 2b of the Constitution as well as section 195 thereof. 28, no new documentation will be relied on other than what has already been annexed in brackets AGTM2, the Constitutional Court Affidavit, Annexure TMZ3, close brackets, here too, full stop, close quotations. The applicant does not make any effort in his discussion of this cross-examination theme to demonstrate how it is necessary and in the best interests of the function of this commission that he should be granted leave to cross-examine Mr. Gordhan on these issues or on this theme. And that would be a reason why leave should not be granted, that he should cross-examine Mr. Gordhan in regard to that issue. The last cross-examination theme is cross-examination theme 5, and that's about the role of the so-called ROC unit. Under this cross-examination theme, the applicant seeks leave to cross-examine Mr. Gordhan on the alleged ROC unit, its existence and lawfulness. The applicant does not say under this theme what it is that Mr. Gordhan said in his affidavit or evidence before this commission that implicated him in state capture or corruption in regard to the unit. Interestingly, the applicant states in paragraph 30.1 of his founding affidavit under this theme, and I quote, this issue plays a central role in that the existence and lawfulness of the ROC unit was repeatedly and independently exhausted. The likes of Minister Gordhan falsely assert that this is not the case. In this regard, I attach a copy of this Kakane report as Annexure TMZ4. I will soon also provide a copy of the KPMG report in due course, close quotes. The question arises, if the existence and lawfulness of the alleged ROC unit have been repeatedly and independently exhausted, why is it necessary and in the best interests of the function of the Commission to allow cross-examination on it? In his opposing affidavit, Mr. Gordhan points out that the SARS Commission considered these very issues in regard to the unit and concluded that the unit was lawful. It seems to me that the applicant has not shown that in regard to the so-called ROC unit, it is necessary and in the interest of the function, best interest of the function of the Commission, that he should be granted leave to cross-examine Mr. Gordhan. In his supplementary affidavit, the applicant indicated that he or his legal team had had the opportunity of studying the transcript of Mr. Gordhan's oral evidence. He said that except for one issue, he saw no reason to add to what he had already covered in his founding affidavit. He said that the exception related to Mr. Gordhan's evidence regarding his laying of criminal charges relating to the so-called ROC unit against him with the Hawks on 15 May 2015. The applicant quoted what Mr. Gordhan said about him having laid charges against him. The applicant said, and I quote, about that issue, Gordhan had the following to say: "This envelope contained 27 questions addressed to me from the Hawks, demanding that they be answered by 2 March 2016. The questions related to the high-risk investigation unit within SARS formed years earlier. Charges against me relating to that unit had been filed by Mr. Moyane on 15 May 2015, full stop, close quotes." After quoting this passage, the applicant says, "I intend to cross-examine Mr. Gordhan extensively on this issue so as to assist the Commission in evaluating a number of issues which the applicant sets out." He gives a list of 3 issues. He says that these are: A, the actual events and evidential material which led him to lay charges against, among others, Mr. Gordhan, so as to assess whether or not there was probable cause, or whether, as implied by Mr. Gordhan, I was out of malice and personal vindictiveness and the like. The credibility, that is B, the credibility of Mr. Gordhan as a witness, and whether anything he says, including his implication of me in alleged state capture, can ever be taken with anything less than a pinch of salt, close quotes. C, his motives in painting himself as innocent, untainted by state capture, and a paragon of virtue, namely to conceal his own central role in state capture, close quotes. Out of all these 3 issues that the applicant has set out in the paragraph to which I've just finished reading, in the preceding paragraph, the only issue that has caused me some concern is one relating to the allegation that Mr. Gordhan alleged malice on the part of the applicant in laying charges against him. When one reads Mr. Gordhan's founding affidavit, there are places where one gets the impression that he may be suggesting that in laying charges against him, the applicant was part of a scheme that sought to capture the national treasury. But when one reads certain paragraphs in the founding affidavit, one may also get sometimes the impression that what he says in that regard might be limited to the Hawks, who served him with 27 questions when they were under the leadership of General Ntleveza. Also, when one has regard to Mr. Gordhan's opposing affidavit in responding to the affidavit of the applicant, there one sees that it appears that he might be equivocating with regard to whether he presses the point relating to what the motives of the applicant were in laying the charges. But also when one has regard to the applicant, one can see that in paragraph 5 of his affidavit, where he sets out what I've called in paragraph 6 rather, not paragraph 5, in paragraph 6, where he sets out what I've called the paragraph 6 issues in regard to which he sought leave to cross-examine Mr. Gordhan. There is no reference to any allegation by Mr. Gordhan that he acted with malice, or he was accusing him of malice in laying the complaint. It seems to me that it would be better that I get clarification from both sides in regard to this issue before I make any final decision. I therefore propose that in regard to this particular issue, I will issue directions in the next few days in which I will set out clearly what I would like both parties to address before I make a decision in regard to that issue. Other than that issue, I'm satisfied, having regard to all the circumstances, that there is no other issue in regard to which the applicant should be granted leave to cross-examine Mr. Gordhan, and therefore, in regard to all other issues, the applicant's applications falls to be dismissed, and in regard to the issue to which I have referred, that issue remains reserved, and I will issue directions and direct the parties to file written submissions so as to afford me more clarification as to exactly where they stand in regard to that issue. Once all the written submissions are in, I will give the issue further consideration and announce my decision in due course. Therefore, the decision I make is the following. A, subject to B below, the applicant's application for leave to cross-examine Mr. Gordhan is dismissed. B, directions will be issued in the next few days for the parties to deliver written submissions in regard to the issue of whether or not Mr. Gordhan's position is that in laying charges against him, the applicant did so with malice, and both parties will submit written submissions, and then I will make my decision thereafter. That is my decision.
Noted. Thank you, Chair.
I think we'll need to take the tea adjournment now.
Yes, Chair.
And then we can proceed after that. It's 11 o'clock. We'll adjourn and resume at 11:15.
Thank you, Chair.
those who might not have been here earlier on, good morning to everybody. Thank you.
Morning again, Chair.
Yes, Mr. Pretorius.
Thank you, Chair. Before the adjournment yesterday, Mr. McBride, we were dealing with the transcript of the telephone conversation at page 1557 of the bundles, which is YD. We had got to page 1564, and we were discussing the list of persons at the top of page 1565 who were at the very least subject matter of an investigation. Do you see that list of persons at 1565?
Yes, I have it.
That list would have included Mr. Mashlangu, one of the speakers on the transcript, as well as yourself as ED,
That's
Executive
correct.
Director.
Yes, that's correct.
Now, you're going to tell the Chair in a moment, hopefully in a moment, of the investigation conducted by IPID into certain police officers and of what is referred to as a counter-investigation by those police officers or persons associated with them into IPID. And we will deal with that. That matter eventually came before His Lordship Mr. Justice Tuchten, who dealt with the resultant dispute and matters arising from the investigation and the counter-investigation. So we will explain the origins of that list of names in due course. But what you have already told the Chair is that the context of all this is what you described as at least a questionable counter-investigation by police into IPID investigators.
Yeah, that is correct. I think the larger picture is important because it exhibits the extent to which police are not doing their work and are busy with protecting themselves from previous and continuing wrongdoing.
All right. Now we're going to come to that in a moment. If we could just complete the references in the transcript and go to page 1566. At the top of the page, the English portion reads, "Okay, I don't know, but if you have something on those seniors, you will present it along. Then you'd explain what they were up to. We had a meeting on that date. They briefed us on what to do, which I personally know that." And this is now a person referred to as male 2. Do you know who that is? Perhaps Mr. Mashlangu will give some clarity in respect of that. But once again, the theme that emerges is that the persons involved in this telephone conversation seem to be talking about the obtaining of evidence in respect of a counter-investigation and cooperation required in order to obtain that evidence against the background of an offer of promotion. Do you see that?
Chair, yeah, except I don't know the exact context and why it's mailed to. If I hear it, maybe I'll be able to see whether there's
All right, well, let's just summarize your references to this transcript insofar as we are able. This is a transcript of a telephone conversation of an uncertain date between a Mr. Mshlangu, an IPID investigator, and Mr. Nkhomo, a senior officer in crime intelligence. Correct?
That's correct, sir.
The first part of the conversation deals with what is in effect an offer or a prospect of a substantial promotion to colonel in criminal intelligence, in crime intelligence.
That's correct.
Correct?
Yes.
There is then a brief reference to a fear that this might constitute favoritism or corruption, and those issues are dealt with. There is then a discussion on evidence in relation to a criminal investigation where Mr. Mshlangu might be an accused.
That's
and
correct.
He is clearly speaking to Mr. Nkhomo about bringing evidence against his co-accused.
That's correct, yes.
And you say this is the counter-investigation.
That's correct.
In that context, you are said to be going down.
That's correct, yes.
Right? And then finally, we see indications, which Mr. Mshlangu will explain, or suggestions of finding evidence
Yes, that's
in
correct.
pursuance of what is being discussed. If we can move on then to paragraph 79 of your statement. You have told the Chair already in another paragraph about your discovery when you returned after your suspension that cases being investigated by IPID had been prematurely closed without carrying out proper procedures, and this was done in certain instances, you say, to manipulate the statistics upwards.
Yes, that's correct.
You have already told the Chair that this was intended to portray an impression that performance had been better under your replacement on an acting basis, Mr. Moyane, better performance than under your watch.
That's correct.
And you say that the Auditor General had noticed this issue.
That's correct.
What happened as a result of your investigations into these facts or allegations? Were there any disciplinary proceedings?
Yeah, there was a disciplinary investigations into Morema. I'm not sure the outcome and which stage it was, but Mr. Morema left soon afterwards. He was also one of those who I never saw again, and there was an investigation into the special closures, and one employee was eventually dismissed. There was also a criminal case that was laid at Pretoria Central about defeating the ends of justice with some of these cases. And I think one of the people in terms of the internal disciplinary and the criminal case as a suspect was Mr. Monyane himself. And he also then left. He was then transferred to the DPCI.
All right. Do I understand you correctly, one employee was dismissed and another employee resigned, and there were others who were also subject to investigation in relation to these issues?
That's correct.
Of, in effect, falsifying statistics by closing cases prematurely and improperly.
That's correct, yes.
All right. Let's move on then to the counter-investigation that we flagged earlier in your evidence. At paragraph 80, you deal with the investigation conducted by IPID into the then acting National Commissioner of Police, General Patlani.
That's correct, yes.
Please briefly provide the background to that investigation.
Okay. So during my suspension, at some stage, March 2016, Paul O'Sullivan was approached by police officers at some stage prior to that. As a result, he then laid a complaint with IPID, and the complaint dealt with, I think initially substandard equipment at the forensics lab, including, if I remember correctly, some chemicals that were used in the testing and, for example, fingerprint brushes. So the fingerprint brushes have to be of a particular specification, but instead a significant amount of the wrong brushes were bought. And a complaint was laid, and the complaint was given to initially Morema and Homo to deal with. One of the witnesses who had approached...
Sorry, before you go on, at that time, was Mr. Homo part of IPID?
Yeah, he was appointed in August 2015 into IPID.
In any event, you say there was a complaint laid with IPID about the conduct of General Patlani.
That's correct.
In broad terms, how would one categorize those complaints?
Initially,
you deal with that in paragraph 80.
80. Well, the issue is about a corrupt relationship with General Patlani, or the allegations of a corrupt relation, General Patlani and a number of service providers.
Okay.
And that was the initial thrust of the investigation.
That was brought to the attention of Mr. Monyane during your suspension, as I understand it.
That's correct, yes.
Was that case then brought to your attention?
On my return, Paul O'Sullivan sent a complaint to me requesting the status update of the case, which a few months earlier he had complained about to IPID.
Is that when you discovered that two files had been opened and both of them had been closed on account of the fact that they were duplicates of one another? You mentioned that in paragraph 81.
Yeah, not immediately. It's only after Mr. Sissoko came back that I was made aware of the extent of dysfunctionality and wrongdoing. So at that stage, Mr. Sissoko is not back yet. I think he only comes back either December or January. And that is directly linked to how we comprise the task team to then deal with the Patlani investigation.
You do mention the duplicate files being closed in the same paragraph where you talk about O'Sullivan's complaint, but you say they're separate in time.
Yes, it's Mr. Sissoko who briefed me that this is what was going on.
In any event,
upon his return.
As a result of the complaints laid by O'Sullivan and as a result of the matter again being brought to your attention, was a task team established?
Yes,
when was the task team established in relation to your suspension and return? You deal with that in paragraph 82.
Yeah, it's round about November, towards the end of November, we established a task team. It could have been 1 or 2 weeks earlier, but
What year?
2016.
Are you back by this stage?
Yes, I'm returned to work on 19th of October.
So there's a complaint about corruption or corrupt relationships alleged between General Pahlani and service providers.
Yeah.
That is brought to your acting predecessor, Mr. Monyane.
That's correct.
On your return, you receive a further complaint by Paul O'Sullivan that these matters haven't been attended to.
That's correct.
A task team is established.
Yes, that's right.
Okay. Who were members of that task team?
If I can just add also, during the period, members of Pop Crew also made an appointment and came to see me at the office about the same complaint. Round about end of October, beginning of November also. They had indicated to me that they had some interaction with Mr. Mandla Mahlangu. And as a result of that, I requested a briefing from Mr. Mahlangu, which he gave to me, indicated he knew a bit about the case and that Morema and Khomo were handling it.
All right. Was Mr. Mahlangu part of this task team?
That is the reason why I appointed him to head the task team, because he had some knowledge of it.
And we know, is this the same Mr. Mahlangu as the person who participated in the telephone conversation we've just dealt with?
That's correct, yes.
Right. Who else was on the task team?
Initially it was Mr. Temani Binang and Mr. Mancha Rapesu. And later on, Mr. Nkabinde was conducting a course or was attending a course in Pretoria. He's based in the KZN office. And he approached Mr. Mahlangu to request to be placed on the task team. And Mr. Mahlangu wrote to me and requested that he needs extra help on the task team.
Now, if you would go back to page 1565, please. This is the transcript of the telephone conversation.
Okay, I have it.
It seems that there is some coincidence between the members of the task team that you refer to in paragraph 82, who are now investigating General Pahlani,
That's right.
or Acting National Commissioner Pahlani on the one hand, and the list of persons who are the subject matter of the collection of evidence and potential charges on page 1565 at the top of the page.
That's correct.
Kabindi, Binang, and Mahlangu are mentioned there.
That's right.
So what is the link?
Well, the link is that that list on page 1565 includes complainant and investigators dealing with the complaints related to the forensic lab, which at relevant times were under the command of General Pahlani.
So what appears to be happening on the face of it, and there will be further evidence to deal with this and place it into full context with further facts, is that Mahlangu is approached with an offer of promotion or the prospect of promotion to testify against a range of people, some or all of whom, or some of whom are members of the task team investigating General Pahlani.
That's correct, yes.
And that, I understand from your evidence, which you're going to give to the chair now, is part of what was termed a counter-investigation.
That's correct. I just want to add a small point on. At the time when this task team was set up in November, Mr. Mahlangu, during his regular reports to me, indicated to me that he met Khomo in the passages, and Khomo said to him, There is nothing in that case. We looked at it already, meaning the Patlani case. And when he told me that, I said, just ignore it. You go and investigate and see what you find.
What was, in paragraph 83, you deal with the subject matter, and this is relevant to the counter-investigation of some of the investigation against General Patlani. What was that subject matter?
Okay, initially the issue was that one of the service providers, that sort of information, had assisted in the funding of the building of Mr. Patlani's house. And
funded by whom, allegedly?
By the service provider. I think it was, service provider was called Criminalistics. They were also involved in for forensics equipment, if I remember correctly. And another aspect to it was, and at the initial stage the link was not seen, was that a motor car dealer provided vehicles to the Patlani family and other police officers, basically gratis. Later on they would claim it was sponsorships, but usually a sponsorship is for some community work or something like that. But these cars were on the Patlani names and were insured by the Patlanis.
During January of 2017, was a search warrant issued and executed at the home of General Patlani?
Yes, yes, that is correct. The purpose of the search warrant was to verify information received that indeed a sound system had been installed in Mr. Patlani's house, and it was facilitated and processed by a service provider.
Right. Was that search warrant then the subject matter of a civil suit?
Yeah, I'm referring to it in these terms because there are a number of search warrants that come afterwards. But this is the initial search warrant, which was a search and identify. And indeed, General Patlani opposed the validity of the search warrant. Now, I just want to add this. Whatever the outcome, and the litigation is still ongoing, and whatever the outcome of the litigation, it will in any event be moot, because General Patlani himself admitted that the system is installed in his house. So the purpose of the search warrant to search and identify the system was in any case negated subsequently by General Patlani.
Would you refer to the testimony then of one of the original task team members, that's the task team to investigate General Patlani,
Yeah.
Cedric Nkabinde,
Yeah.
also one of the persons on the list
Yes.
in the telephone conversation transcript?
That's right.
What happened in regard to him?
So, General Patlani in 2017 launched the challenge to the search warrant. All well and good. A response from IPID side was given, and General Patlani identified from his perspective a number of technical issues with the search warrant. All well and good. However, the matter lay dormant for almost 18 months, and upon the removal of Nkabinde from the task team and upon his resignation, we became aware that General Patlani is initiating and attempting to re-enroll that initial search warrant challenge based on evidence, testimony he got from Nkabinde. Without going into the detail, the testimony from Nkabinde on his affidavit ended with a paragraph which in effect was saying, I'm available to make statements for any other police officers having problems with IPID, and I've instructed my attorneys to make me available for it.
All right. Thank you. Would you go to paragraph 87, please?
I have that.
Just tell the chair what you say in that paragraph, please.
Okay. So I want to pause here and go back to when the initial investigation into the case of corruption and money laundering was initiated against Patlani. O'Sullivan was the complainant, and also because of his background in the matter, he and attorney Sarah Jane Trent accompanied IPID investigators to the Sable Hills estate to point out witnesses that he had identified to IPID investigators. I think perhaps yesterday I had said Trent was a secretary, but I'm reminded now that indeed she is an attorney.
Right.
And these witnesses later gave statements which included statements related to the investigation and provided clarity on the rate of development of the house at Sable Hill and other matters relating to who the contractor is for the house. And I think there were discussions and a statement from the contractor also.
What you refer to as the Sable Hills house, is that the same house in respect of which the search warrant you referred to earlier was granted?
That's correct.
And executed?
That's correct.
Right. So now we have a task team investigating General Patlani, and we have the complainant as Paul O'Sullivan.
That's correct.
And to an extent, at least, his attorney, Ms. Trent.
That's correct.
Right. What happens then? You deal with that in paragraph 88, if you would refer to it, please.
Okay. Okay. As a result of the visit to Sable Hills residential estate, a complaint was initiated within the police services by General Patlani that there was a security breach at his house and that his life is now in danger. He then requested Acting Divisional Commissioner Machele for her to establish a team to investigate the security breach. At some stage in his contact with General Machele, General Patlani also contacted General Jan Mabula and his team from Northwest. Now, an investigation was carried out by crime intelligence on the alleged security breach. A record of that report has gone missing. It's gone through the hands of 4 generals, and they can't provide it, because allegedly that report is what resulted in General Mabula and team getting involved. However, it subsequently became clear that they had been involved prior to the completion of the report. And secondly, that the people who conducted the report, upon realizing that IPID was doing an investigation, came to the conclusion that there is no security breach. It was IPID doing the investigation, and they made a report to that effect.
You say that report went missing.
Yes.
You talk of a second charge of defeating the ends of justice that was registered against the Mabula team and other generals.
Yes.
It's all very complicated.
Yes, yes.
But essentially what we have, as I understand your evidence, is an investigation into General Pahlani, an investigation now into other generals, particularly from the Northwest, and a counter-investigation for security breach and the like in the execution of the search warrant and related matters. Am I correct?
That's correct, yes.
All right. Let's go then to paragraph 90. What happened during the course of the investigation and counter-investigation?
In essence, the Mabula team moved to Gauteng. So from Northwest they came to Gauteng and they set up in a hotel in the CBD of Pretoria, or just outside the CBD in Arcadia, and were basically permanently based there for, I'd say, almost a year. And the only purpose for being there was dealing with O'Sullivan, Trent, and IPID.
And if you would have regard to paragraph 90 and then 91, please, and tell the chair what you say there.
Okay, so 91, I said, their counter investigation resulted in a case being opened, the Camille case number 1201-2017 against O'Sullivan and Trent. The charges related to them were, amongst others, of accompanying IPID officials to Pahlani's Sable Hills home and impersonating IPID officials.
So, as part of the execution of the search warrant, O'Sullivan and his attorney accompanied IPID investigators. Is that correct or not?
No, that's not correct. This is prior to a search warrant even being obtained and prior to a search warrant being executed.
Yeah, but is it correct that O'Sullivan and Trent accompanied IPID investigators to the Sable Hills premises, or estate rather than the home?
But not during the search warrant execution.
Okay, I understand. And on the basis, is it on the basis of O'Sullivan and Trent accompanying the IPID officials that they were charged with impersonation of IPID officials?
Yes. So they were with IPID officials, but they were charged for impersonating IPID officials.
And this was part of the investigation in relation to the complaint
That's correct.
made by O'Sullivan, is that right?
That's correct.
Were O'Sullivan and Trent arrested?
Yes, indeed, they were arrested.
You mention in paragraph 92 an incident that occurred during the course of that arrest. What is that?
Yeah. During Trent's arrest, her mobile phone was confiscated by the Mamula team and booked in for investigation in order to support charges that were being fabricated against the pair and later on the IPID investigators that were added. So at different occasions, both Trent and O'Sullivan were arrested. And I think O'Sullivan was arrested twice for the same case. One of the instances, I think there was bail given, and the bail had conditions attached to it. And so which did not necessitate the second arrest. Some undertakings were given during the first arrest. In any event, O'Sullivan was arrested twice by Mabula team.
I'm sorry, just to go back to impersonation. As you understand it, what was the factual basis of the charge that they were impersonating IPID officials? Were they wearing any uniform that IPID officials wear? Were they alleged to have said they were IPID officials, as you understand the position?
From what I remember, Chair, there were no specifics attached to it. Mainly it was related to the fact that they accompanied IPID officials and that they had spoken to witnesses who provided statements. I will just hasten to add here that at a later stage, the Mabula team visited every one of those witnesses and got them to change statements.
The ones on the basis of which the charges had been put together of impersonating?
No, those who made statements implicating General Patlani
Oh, yes. Okay.
in
Yeah.
the corrupt relationship
Yeah, okay.
and so on. Every one of them was visited and altered their statement to some extent or another. People who had indicated that they had seen bags of money being paid over to the contractor, that is in cash.
Suddenly they could not remember well.
Subsequently, with the after the Mabula team have visited them. So that's what's resulted in the defeat in the ends of justice. I think the second one being opened up against the Mabula team.
So, against the background of the information in the telephone conversation transcript, you have Khomo talking to Mahlangu, one of the task team members investigating Patlani,
Yes.
about giving evidence against other members of the task team about collating or obtaining evidence and the like. The precise wording used is instructive, but we can deal with that when Mr. Mahlangu is called if he comes to testify. So what you have basically is an investigation to General Patlani and what you've referred to as a counter-investigation.
That's correct, yes.
That issue was taken to court
Yes, that's correct.
and was dealt with by His Lordship Mr. Justice Gordhan.
Yes.
In the annexures to your original statement and the original annexures, there is at least part of the judgment of His Lordship Mr. Justice Gordhan, but it's incomplete. So we've obtained a proper copy of the judgment together with the order granted. It's Exhibit Y2, Chair, and it's been handed to your registrar.
Thank you.
Not going to go into it in any detail, but just to highlight certain aspects of the judgment and order. If you would just look at page 1 of Exhibit Y2. Is that the matter where IPID is the first applicant, you are the second applicant, Mahlangu is the third applicant,
Yes, yes.
and Benang, another member of the task team, is the fourth applicant.
That's correct, yes.
The respondents are Lieutenant General Patlani and certain other persons including Major General Mabula.
That's correct, yes.
Were they to some extent or another involved in the counter-investigation against IPID and others, or members of IPID and O'Sullivan as well?
Yes, yes.
There's a related matter that obviously was joined, involving others as well.
Yeah. If I can just give the context of this is, for the Mabula team to leave Northwest and come to Gauteng, they would need the provincial commissioner's permission. To come and work in Gauteng, they would need the provincial commissioner of Gauteng's permission also. And that is why they are cited for allowing them to come into Gauteng to work in supposedly an offense they're investigating which occurred in Gauteng. And just to indicate that Mahlangu is investigating Patlani and was part of the initial team whilst I was on suspension still, and that Binang was investigating General Mabula and his team from 2011 already under ICD.
So we have two IPID investigations that form the background to this application before His Lordship Mr. Justice Tuchten.
Yes, yes.
They are an IPID investigation into General Patlani and an IPID investigation into General Mabula. General Mabula and others now come to Gauteng to conduct what we call the counter-investigation.
That's correct, yes.
All these events are relevant to the transcript of the telephone conversation that you have spoken about and about which there may be further evidence.
Yes, and I would just like to add there, Chair, is that indeed it is the same Homo who took Mandla Mahlangu to Potchefstroom to meet with Mabula and Ngube to concoct a story. But so the team is investigating these people, yet Homo is the person that takes them to Mabula. The fact that Mabula sees them is sinister for the bigger games at play here, in addition to this litigation that's going on.
Okay. Can we go to page 12 of Exhibit Y2, please? After obviously hearing the parties, the judge concludes in paragraph 22, as background to the declaration he makes, in formulating the declaration I shall issue, he says, I bear in mind the important special position IPID and its investigators occupy in our constitutional architecture. Members of SAPS have enormous powers. They can deprive people of their liberty and intrude upon their private spaces, either without prior oversight at all or where oversight is required, as in the cases of arrest or search and seizure under the authority of a warrant, necessarily without the subject of the action being heard on the question. All members of SAPS can decline to exercise those powers. The potential for abuse is obvious. That is, to my mind, the primary reason why IPID exists, to investigate complaints of such abuses. I bear in mind, too, that members of SAPS are constitutionally obliged to protect the independence and effectiveness of IPID. It is of the utmost importance that members of IPID, and I may say of SAPS as well, are able to carry out their duties vigorously. And then there's reference to the Constitutional Court judgment in Glenister. Over the page on page 13, the judge continues, of special concern to IPID members as demonstrated by the allegations in the present case is the risk of what I might term a revenge investigation, i.e. the risk that a member of SAPS, subject to or fearing that an IPID investigation might use the powers vested in that SAPS member to conduct a counter-investigation against the very IPID member investigating or likely to investigate the SABC member. If I may interpose there before quoting further, that is precisely as I understand what you say happened.
That's correct, yes.
Paragraph 25 reads, "It must seldom, if ever, be necessary for a SABC member in the position I have just described to participate in such a counter-investigation. Perhaps the participation in the investigation of such a SABC member can be justified on the basis of very scarce skills or knowledge without which the counter-investigation cannot be conducted. In such a rare case, the SABC member in question would have to be subject to a stricter level of oversight to ensure that the IPID investigation was not compromised." He then refers to a certain section of the IPID Act and seeks to apply that to the facts before him. And if we can refer, please, to page 21, which is a draft court order. It was a consent order, is that correct? In other words, the parties agreed to the order. And the first respondent there agreed not to take part in the investigation.
Yes, yes.
That is the counter-investigation to which you've referred.
That's correct, yes.
And a further draft order appears at page 24 of Exhibit Y2.
Yes, yes.
Where an undertaking was given by Deputy National Commissioner Lieutenant General Mfazi in the capacity of the Acting National Commissioner, that certain members would be removed from the counter-investigation. And those persons are Major General Mabula, Brigadier Ngubi, Lieutenant Colonel Darwood, Brigadier Khorani, and Colonel Reddy. You see that on page 24.
Yes, that's correct, Chair.
So whilst the counter-investigation was not stopped, the outcome of the litigation, the application, was that persons who might have an interest in the outcome of that counter-investigation were removed. Am I correct?
That's correct. Chair, I just wanted to check. I don't have, my page 25 is blank.
Mine is blank too.
No, I'm referring to page 24. Are you saying that if you go to page 26, that is the completion, as I understand it, paragraph 4 of that draft order there on page 24. So you can ignore page 25.
Okay.
The undertakings were made by the respondents, we should place on record, without any concession or admission of liability. But the net effect of the application was the removal of certain interested persons in the counter-investigation.
Just to add that key element in summing up in a judgment was that IPID has a provision in its act, in section 25, that no investigator may be involved in an investigation in which he has any interest, and that SABC does not have a similar provision. And at some stage there was a directive that the necessary changes to the legislation or regulations of SABC needs to be done. But
to provide for a similar
that's
provision.
correct. That's correct.
Right. In paragraph 94, you continue your evidence in relation to the counter-investigation.
Yes.
This would have been, just want to check its relationship in time to the application to court before Judge Tuchten. Before that application, the events which occurred in paragraph 94 would have occurred. Is that correct? Or not? Do you see what you say in paragraph 94? If you could have regard to it, please.
Yes, I have it. Yes.
In relation to the application before Judge Tuchten,
Yes, yes.
when did the events in paragraph 94 occur? Before or after?
It would be before the Tuchten judgment.
So before the Tuchten judgment, the events in paragraph 94 occur,
That's correct, yes.
and were probably relevant to the need, I understand, for the bringing of the application at all.
That's
What
correct.
happened in May 2017?
So, during May 2017, Brigadier Ngube of the Mabule team, on the instruction of Advocate Molatlwa Mashuga, charged IPID investigators Mahlangu and Binang for allegedly contravening the IPID Act.
Just to remind the Chair, Mahlangu and Benang were part of the task team set up by yourself to investigate Pahlani.
That's correct, yes.
Right. And were certain other accused or alleged accused joined to that proceeding?
Yes, yes, Chair. Mahlangu and Binang were then joined to O'Sullivan and Trent as co-accused. I think in the transcript, Mr. Mahlangu refers to this and indicates that he was accused number 1 or 2 or number 3. He's accused number 3 at some stage. He's referring to this where they're all charged together. On page 1563, he says, I was accused number 3 when he's talking about, when Homer was about adding other co-accused on. So this is what Mahlangu is referring to.
The incident you refer to in paragraph 95, before you testify to that, is that of your own knowledge, or is that information received by you?
No, that's information received by us.
What is the information received by you?
The information is
Maybe
that,
the subject of our own investigation.
yeah, that Trent was arrested and after being driven around for a while, was then interrogated and asked for her phone, and then taken back to go and get the phone at the office where she was arrested. This was at least an hour and a half later, and the phone was then taken. The phone was not part of a search warrant or relevant to any charge of impersonating an IPID officer, which were the charges at that stage. The phone was then, the chain of evidence of the phone was lost. Rumors from within the police itself was that the phone was taken to Israel to get it downloaded.
In paragraph 96, you talk of charges being brought against Mahlangu and Benang, who were members of the IPID task team.
That's correct, yes.
Is that the same occurrence that you talk about in paragraph 94?
That's correct. So what is key in 96 is when Ngube came to IPID offices to take the warning statements of Mr. Binang and Mahlangu, I became aware that he's in the building. So I then approached him and to ask him, is it true that you're from the Northwest? And he said, yes, he's from the Northwest. So I asked him, how is it that you came here to Gauteng to carry out an investigation against my officers? And I indicated to him that he is he aware that he's a suspect and a part of what he's doing is defeating against his attempt to defeat the ends of justice? He's a suspect in that investigation. He then decided to charge me for intimidation because I inquired how did he come from Northwest to be functional in Gauteng. I'm not sure where that case is. I gave a warning statement to the investigator, and I'm sure it was thoroughly investigated.
You referred earlier in your evidence to an occurrence that is or was not uncommon in relation to people in your position, that you would be charged and charged again and charged again.
Yeah.
After the charges in the rendition saga, how many times after that were you ever charged with any offense?
Well, complaints were laid, but it never went to court, yeah.
Okay.
It never went to court. Even on the, we know that documents were prepared to make the whole case, which started off as a security breach, into racketeering. And that is what Home was talking about. He's going down, and all of that is about the plan, the ruse, the concoction, but it never comes to fruition. Perhaps as a result of Tuchtin judgment, and that no other prosecutor would want to touch something so obnoxious.
Right.
1 second, Mr. Pretorius. Registrar. Thank you. You may proceed.
On what basis were charges contemplated in relation to yourself of racketeering? Do you know?
Off the top of my head, I can't remember what it was about. At one stage, I was, Cedric Nkabinde brought a member who identified himself from crime intelligence and said he was aware of a conversation taking place to charge me, and it was the Mabule team, and in particular Ngube, talking to a prosecutor in order to obtain an arrest warrant. And the crime intelligence person, asked me, is there any way I can help with this? So there was an arrest warrant being prepared, and I said to the crime intelligence guy, well, I'm investigating corruption. There is no way I can come to any agreement or understanding or reconciliation. They are suspects of IPID, and so it can't happen, so they must do what they want. My suspicion, it might have been to do with Nkabinde's double game he had been playing. So, and basically, in short, the allegations were that there was a conspiracy to undermine the security cluster by targeting SAPS officials.
Let's just summarize then at a general level. Arising out of the rendition series of events,
Yeah.
you were charged.
Yes.
You were also suspended.
Yes.
The charges came to naught.
Yes.
You returned after your suspension and you continued investigations or IPID under your watch continued investigations into senior police officials.
That's correct, Chair.
Further charges, both in relation to the counter-investigation and other matters, were contemplated at least or prepared against you.
That's correct, yes. Just to add, on some occasion, the official who took over from General Sebia in Gauteng, Prince Mokotedi, on an intelligence report, laid a charge of treason against myself, General Sebia, Paul O'Sullivan, and I can't remember who else. And eventually, Mokotedi admitted to Mr. Sesoko that they were not after me. Patlane had a bone to pick with O'Sullivan, and that was the basis of that. And he was basically under the instructions of Ntlemeza. So that was immediately upon my return. Immediately, it would have been December or January. So it's been quite relentless, and it's been continuing. And the plots and the schemes and the conspiracies continued non-stop.
And do you think the motive or aim was to drive you out of IPID, or at least to deter you from any determination you might have had to fight corruption with the vigor that you might have displayed before? To try and slow you down and soften you? Do you think it's either of the two that they might have wanted to achieve with you in particular?
Chair, I think it includes what you have said, but it also includes spending resources on harassment and disruption of IPID's activity. It is the same tactic that they use when they're dealing with criminal syndicates. If they're doing their work properly, they will disrupt and they will tie them up in litigation and all of that. Now,
basically to keep you away from your work.
From your work. Mm. And all of what they have done has delayed us. To add insult to injury, they had willing collaborators within the prosecuting authority who assisted in this process. But SAPS, and I just ask for your indulgence for me to just divert a bit. SAPS runs on a patronage system. I do favors for my senior, I get promoted. Promotions, like what we see with Homo and
Mahlangu.
With Mahlangu, but also with the other Mahlangu and Mr. Kuba. What you see is they have the willingness and power and practice and custom to offer out jobs as patronage. And that's how the police system works. It works on patronage and people being promoted and appointed to carry out tasks on behalf of seniors. And that's how it's been running. You take that and it's related to, so promotions within the forensics lab area will be related to assisting and facilitating further corruption and maladministration. And in that process, everybody has an interest in protecting the seniors, because it indeed is the seniors that put them there. They might even feel under obligation to protect. They also have a process where sometimes people who are in the same college together or come from the same village or at the same station, and They might have been in patrols together. They might have survived shootouts together. So bonds are formed between them on various reasons, including patronage. And unless you have a strong hand about good governance and respect for the rule of law and the Constitution, you'll never get the SABC right. And it's a system that's not been challenged. It's a system on its own. It affects all aspects of our life. Criminal syndicates and corruption syndicates, not that there's a difference between the two, require good senior policemen not to investigate past acts of corruptions, current ones being committed and ones in the future. That's how it works, because the intention of a corruption syndicate is to steal money. And in the instance I'm talking about, and if it's requested, I can show a litany of cases where billions have been stolen. The best person to deal with that would be Mr. Soko, to outline step by step all the theft and how it works. The point I'm making is that we will have this commission. Your Lordship will make recommendations and they will be carried out. But the patronage system within the police service will stay unchanged. And politicians who require compliant senior police officers will come and go, and they will use the police service for their own interests. And that's what will happen, and that's our experience, where very often we immediately at loggerheads with the Minister of Police, whoever it is, regardless of personality. Because the Minister of Police is responsible for the police. Police must shine, is under their executive authority and watch. And every time the police shine and the image is being polished, up pops a case from IPID, which might become an irritant, and there is an institutional tension there. But it's precisely because the practice of patronage and corruption within SABC. So, if we have to go back, how far back do we go? For example, the removal of Dramat and the installing of Ntlemeza. Ntlemeza immediately appoints other police officers. They get rid of Sibia, they get rid of Boyson, and they put other people in place. And they've appointed people, people got transferred out of DPCI into the greater SABC, and new people are installed.
And of course, was it in the conversation that was recording it yesterday, where there was talk of if you do this, we will remember you, or we won't forget you, or so and so won't forget you. So that's part of what you're talking about.
Exactly.
Yeah. And if you want to be remembered, you need to be pliant. You need to keep that person happy so they can remember you.
Exactly, Chair. And the forces that should be fighting against this patronage system have been sabotaged politically. We've seen it in Tlego. You will find other occasions if you look at it. And by police officers resisting IPID, sabotaging counter investigations, or as referred to in one of the judgments, revenge investigations. In essence, we might take it as personal issues because we are personally affected. We get falsely charged. And we go through our own pain and disadvantage. But for the people carrying it out, it's actually survival. And it hasn't started now. SABC is the oldest organization in South Africa. From the Act of Union, in various forms and evolutions, it started. The idea of being investigated, they don't like. Number one, the idea of any oversight over them, they don't like.
And being arrested.
They don't like that. And the issue of resistance to change because of old cultures and traditions. So it's instinctive not to do it. And the constitutional democracy is relatively new. Notions of constitutional independence, like in IPID, SABC is not accustomed to it yet. They have not been reorientated towards constitutionalism and respect for the rule of law. So that is an institutional and attitude problem which further feeds into the patronage and corruption.
And obviously, if you have that culture in any organization, but talking about SABC now, if that is the position, then it's very easy for those members of SABC who are quite happy to be blind to the seniors, to be actually blind to outsiders as well.
Yes.
So private companies, individuals, yes, criminal syndicates, because they would be, the seniors would offer them either money that they might be getting illegally or offer them positions that will give them money, higher positions. So people outside can give them money and then they would be happy. That's what they would be wanting if this is the position.
Thank you, Chair. There's another side which is even worse. So for the good police officers, the ones that work diligently, that get the work done, that come to work every day and go about their business, who are not in it for being compliant or corruption, they have to start at some stage thinking, what is it all for? This person doesn't do half as much work as me, has half the qualifications, but is promoted above me because they are close to colonel or brigadier so-and-so. What it does, it then demoralizes the good people who are actually holding the ship afloat. And the result is not only you will get them either leaving the service or thinking, why should I work hard? There's nothing for me, I see no benefit. And then they start thinking in terms of their own material situation. And more of them are won over to the crooked side. And this issue of recruiting people as part of the crooked system, as in the 2 recordings, that's ongoing, it's going on all the time. This is late in the Patlani investigation, and yet Mr. Khomo sees fit to do it. Startlingly says, don't go in detectives, you will end up chasing criminals. We don't want to be chasing criminals. I'm not sure what other work police are supposed to do. And what does he imply that...
That's their core function.
Absolutely. So what is he intending Mahlangu to do away from chasing criminals? I suppose he should explain.
Thank you. Mr. Pretorius, I just want us to take 5 minutes break.
Sure.
We'll adjourn for 5 minutes and we'll resume in 5 minutes, 25 to.
Thank you, Chair.
All right.
Okay, you may proceed, Mr. Pretorius.
Thank you, Chair. The counter-investigation, what was the outcome of that? You deal with that in paragraph 97.
Yeah. So the state advocate in the matter was Advocate Mashuka, who also has some links to the Northwest team. The case was remanded several times for investigation until October 27, when the 2017, my apologies, when the accused made an application that the matter be struck off the roll in terms of Section 342A of the Criminal Procedure Act.
That deals with undue delays.
That's correct, Chair.
Was it in fact struck off the roll by the relevant magistrate?
That's correct.
And apparently could only be re-enrolled with the written instruction of the National Director of Public Prosecutions.
That's correct.
Briefly tell the court of the Prinsloo application, Judge Prinsloo application, or the application heard by Judge Prinsloo. And I understand that that application preceded the application that you've referred to before Judge Tuchten.
Thanks. So the order by the magistrate to strike the case off the roll was, and that the investigation be stopped unless there's a written instruction from the National Director of Public Prosecutions, was not adhered to by the Mabula team. They continued with their counter investigation. And then shortly after this, Brigadier Ngube took another warning statement, this time against Mr. Mancha Rapeso. And he also threatened to arrest other members of the task team. In his interview with Rapeso, he basically dropped a remark during the process.
That you say in paragraph 99 that he would arrest other members of the task team, including yourself.
That's correct, yeah.
And what was the purpose then of approaching the High Court?
Well, the High Court was to...
This is the Judge Prinsloo application.
Thank you, Chair. It was to basically obtain an interdict against the Mabula team from continuing with the harassment and disruption of IPID's work.
And the outcome of it's in the bundle, but I want to try and avoid referring to it in any detail, but we can refer to it.
So ultimately there was an order of court by Judge Prinsloo, which was a result of an undertaking that the counter investigations would not continue. The exact provisions would be somewhere in the bundle.
That was an application brought by the Helen Suzman Foundation, is that right? Or was that a different application?
I think the application was brought by IPID.
All right, we'll see if we can find a reference to that.
Okay.
There's another judgment in the bundle by Judge Prinsloo, which we won't deal with now. If you would look, please, at page 24 of your statement.
Thanks, Chair.
From page 24 to page 27, you deal with circumstances giving rise to and the bringing of the application in the North Gauteng High Court, which was heard by His Lordship Mr. Justice Tuchten. You've dealt with that. If you could assist the court, or assist the chair rather, by looking at paragraphs 101 to 118 to see if there's anything further that you want to say in relation to those events about which you have testified this morning.
Yeah, a key element in the whole litigation with the Mabula team is that the then Acting Commissioner General Motiba was willing to abide by the court's decision. But whilst he was willing to abide, Mabula, who had been activated by General Patlane, was writing affidavits opposing it. And his main thrust of his reasoning was that IPID is investigating cold cases. And the cold cases he's actually referring to here involves torture, and including the death of one suspect. And he refers to them flippantly as cold cases, as if somehow because a case is cold, no one can light a fire under it. And during this period, we also had, he becomes increasingly desperate because he's also placed on the scene of one of the tortures and death of a deceased. And yet, paragraph 104, and there's a recording related to that. And in fact, for the record, this recording is made long before I'm appointed at IPID. I think it's made in 2013. That is the recording that initially went missing after having been given to prior to my suspension and after having been given to the provincial head of Northwest province to investigate, the IPID head who subsequently left the department and went into SABC.
Just before you go on, it seems that amongst the cases that IPID was investigating against, amongst others, General Mabula in the Northwest, concerned torture and death in detention.
That's correct.
And these are the cases that were described as quote-unquote cold cases.
That's correct.
Okay. That's the one aspect. The paragraph 106 and 105, you refer to an order of court by Prinsloo J. Is that not perhaps Tuchten J that should be referred to there?
No, it's Prinsloo. Tuchten comes
later.
Prinsloo is in November and Tuchten is in June 2018.
So
Tuchten,
as I understand it, the undertakings not to continue with the investigation by those people were not obeyed, which resulted in further application being necessary, and that came before Prinsloo J. Is that, am I understanding you correctly?
the other way around. It started with Prinsloo J first as urgent application.
You said Prinsloo J 18. Let's get the sequence right. You said 2018 for Prinsloo.
No, 2017, November 2017.
And then Tuchten?
June 2018.
All right, that's the order.
Yes.
All right. But the reason for the second is what you've said.
It's the same reason. They
and
just continued.
They covered the same subject matter.
Yes, that's correct.
All right, but let's just deal with the sequence then in paragraph 109. You say that despite obtaining an order from Prinsloo J, what was the nature of the order obtained from Prinsloo J?
It was along this similar vein that they would desist from carrying out certain counter-investigations.
Or having certain people involved in
That's correct.
investigations who had an interest in the outcome of that investigation.
That's correct. I think it would be better to have the two orders in front of us and we can see the dates exactly.
Well, I just tried to find the Prinsloo judgment. I can't.
Okay.
It relates to another matter.
Okay.
So I'm not sure we have the correct one on file, but we'll attempt to do that. But because you've dealt with the facts giving rise to the judgment by Tuchten J, the same principles, as I understand it, are involved.
Yes, that is right.
You say in paragraph 109, despite obtaining an order from Prince Luce, the Mabula team continued with their counter-investigation against the IPID. And you say they continued harassing and attempting to intimidate IPID members and impede the IPID investigation into Pahlani.
That's correct. Yes.
Right. And you talk about the warning statements there.
Yes. I think it's important at the end of 109 to say that there was a fear and trepidation amongst the investigators because of what they had seen being done to O'Sullivan, Trent, Mahlangu, and Binang. So others were a bit hesitant, and often they would request to see me to say, how should we approach it? Investigating officers of IPID were also not sleeping at home, were moving around and sleeping in different places. For example, we became aware that there was an illegal use of tracking equipment in order to arrest O'Sullivan the second time, which was used by crime intelligence. We are aware that we were being tracked and monitored and our phones interfered with. There's only one other time that I've lived like that in my life, and it was during, as an activist during the apartheid era. And my officials were scared a lot of the time, and it cannot be, overemphasized. But in fairness to them, they did decide to stand firm, whilst a number of them approached. In effect, only one turned, and actively went about sabotaging cases. So this is in a constitutional democracy, 20-something years down the road, and police are behaving like this against the exact body that has been created by the Constitution to prevent abuses. And yet this is what was happening. As far as we are aware, none of the abuses have stopped. It's been passed from one commissioner to another commissioner. It's either laissez-faire or look the other way, allow it to happen, because again, it's the brotherhood of the blue curtain. It's there, and most of our, I must put it this way, in fairness to all police officers, our information on corruption and maladministration in the police service comes from police officers. Mostly yes. From good police officers who want to do their job and don't like what's going on.
And there would still be many of those. I guess that has to be acknowledged.
Yes. So there are people who want to do work. We don't have an intelligence team or an intelligence budget. We have just good citizenry, especially from within the police service, that help us with cases, to identify cases, and of course complaints from the general public who don't like being abused.
The harassment that you have been talking about is primarily aimed at IPID. I know that maybe some of the law enforcement agencies that are supposed to fight corruption might not have been seen to be very effective in the past, so maybe they might not have been targeted. But what's your experience? Is it this kind of harassment from SAPS and crime intelligence being directed at just really primarily IPID?
If I can put it this way, and again we're talking in stages and different stages. By the time the Mabula team came on the scene,
yes,
there was nobody left within policing, within DPCI, within the prosecuting authority, who could, from my opinion, firmly held belief, could give a good account of themselves when it came to corruption. So we were the last organization standing. And we are very small. Nationally, there's only 265 investigators. And the core group did not make up more than 20, the people dealing with special investigations. And those that were sort of the higher up you went, the more the resistance. We did anticipate resistance, the pushback, but we didn't think they would resort to this level, that they'd be brave enough, audacious enough to just go against everything that's good in the country. So,
Yeah, thank you.
Mr. McBride, just to deal with page 24 to 27 of your statement in an attempt to summarize the evidence you've given and to invite you to make any further comment. On your return to IPID after your suspension, investigations into very senior police officials, including an acting commissioner, continue. There are counter investigations to which you've referred.
that's correct.
Those counter investigations involve the very IPID members conducting sensitive investigations.
That's correct.
On 2 occasions, IPID finds it's necessary to approach the courts for one or other form of interdict.
That's correct.
These come before Judge Prinsloo and Judge Tuchten.
That's correct.
We've referred to the Tuchten judgment, and we will try to find the Prinsloo judgment. I think the wrong one may have been filed. Nevertheless, you say, notwithstanding the order obtained before Judge Prinsloo, the investigations, and as you describe it, harassment of IPID investigators continued.
That's correct, yes. It still continues now.
Yes. I'd like to refer then, just before the long adjournment, to paragraph 109, where you say, despite obtaining an order from Prinsloo J, the Mabula team, that's the Northwest team that came to Gauteng, is that correct?
That's correct, yes.
Continued with their counter-investigation against the IPID. Mabula and his team continued harassing and attempting to intimidate IPID members to impede the IPID investigation into Bashlani. Is that your evidence? Do you
That's
stand
correct,
by
yes.
that?
Yes, that's correct.
In paragraph 110, you say, as a result, IPID continued to engage the SAPS, the ministry, as well as the office of the NDPP, trying to ascertain whether the continuing investigation, that's the counter-investigation, I
Yes.
presume, was sanctioned at a senior level. What I want to ask you in relation to your evidence on page 26 is whether, apart from the court applications, attempts were made by approaching people in high office to try and address what was happening.
If I can just go back further, and it's the first time I'm mentioning this to anyone. At a certain stage after my return, I realized that there are counter investigations and that the criminal justice system is shaking or its effectiveness is eroding. I became concerned about national security. I then approached the State Security Agency to call a meeting between all the heads of services so that we could get an undertaking that we will be allowed to do our work, and we might be either investigating each other, but we'll do it properly, and we'll refrain from statements in the newspapers just until we are allowed to do our work. So I was concerned that the crumbling of the whole criminal justice system was basically in effect. And I went to the only authority who doesn't have investigative prosecutorial powers, and they are seized with security of the state, which was State Security Agency, and I went to the DG. The DG arranged a meeting between heads of the department, and it was at least 2 meetings, perhaps 3. In the meetings was the NDPP, Sean Abrams, Acting Commissioner Patlani, as Commissioner Moyane, myself, and the DG SSA. And a number of issues were discussed. We undertook that we will not discuss cases, but that we will manage perhaps difference of opinions or different positions we find ourselves in through the work that we do, through our professional work. In one of the meetings, I think immediately after the first meeting, General Patlani went to the media about something, and therefore the effectiveness of kind of trying to contain fallout from investigations that we were doing and counter investigations, and that the interests of the country must come first. Out of that process, those meetings kind of fizzled off. I engaged with other police officers, Mr. Sissoko and Mr. Kuba, ceaselessly engage with them that we have responsible way in which they respond to IPID. And so from the side of IPID, we went out of our way to avoid litigation, to at least conscientize people about the interests of the state and the Constitution and rule of law. It didn't really work because, and I think I touched on it earlier with that perhaps long input I gave, but it's not, the minds of the people involved in the corruption and the counter investigation are not anywhere near the issue of constitutionality and respect for rule of law. They are there in greed and survival. That's where their minds are. So it's like we're in different dimensions. You're talking different languages to people, and there are different interests. What I can say is that the heads of, Moyane is gone, Abrams is gone, Patlani is in effect gone, and last I went. So the point I'm saying is, in any event, those kind of meetings should have been taking place to maintain the security of the state and national interest, and that well-meant investigations are not thwarted because people have narrow interests. Overall, all these agencies are there to ensure proper governance and to root out maladministration. So I think it's important to say that generally, without adding specifics, which are already is, that there was attempts by IPID at various levels, including engaging and regularly updating the different ministers that were involved. We even sent info notes to Nhlego, even though Nhlego had said he doesn't want to engage with me anymore. I continued giving him reports so that he was aware of the situation, as I did right until my last month at IPID. So the issue of personalities didn't interfere with IPID's professionalism at all, yeah.
Perhaps we should take the long adjournment now, Chair. And
yes.
When we come back, Mr. McBride, we will deal with a summary of the aspect that you're dealing with now, the counter-investigation, and then move on to page 27. Hopefully we can finish this afternoon.
Yes, it's 1 o'clock. We'll take the lunch adjournment and resume at 2. We adjourn.
All rise.